I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into compilation 129. If you follow this channel and you follow the compilations that we've been putting out, the last compilation we put out, number 128, we covered a child support theme in that compilation, but unfortunately we were unable to get all of the child support cases that we've covered here on the channel in that compilation. So I have two more of those for you today in 129, and also we're going to add a bonus proceeding to this compilation. So we will be in 3 different judges' courtrooms. All of these judges will be from out of the state of Michigan. Before I give you their names, just know there will be some commentary in some of these proceedings, and also chapters will be added for your convenience. Now, the first judge courtroom we will be in is that of Judge Jason Elmore. Second, we will be in the courtroom of Judge Colin Hunter. And last but not least, we will be in the courtroom of Judge Marlena Taylor, all out of the state of Michigan. Guys, the compilations have been going great. It has been definitely a great idea to add new, old, past, whatever to these compilations. It has worked out well for everyone. I've been getting the comments, I'm hearing what you guys are saying, and I'm definitely going to keep this going for you. So now, without further ado, guys, let's go ahead and jump into 129.
And now we are down to People of the State of Michigan versus David Thompson, file 24-3559FH.
Yep. David and Houghton, appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here, making his way to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right, well, all right, so we are currently set, so you can have a seat. Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pretrial conference. Today is the last date in which to enter a plea pursuant to any pretrial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have 2 trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials in that 2-day time frame.
And was there a jury demand, I assume?
There was, your
Honor. I'm going to move this to start on February 19th. So that way we have the 1 day to do the other file and the 2nd day to do this case. So I'll issue jury letters to 4 sets. 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct.
You understand the court can appoint an attorney to assist you?
Yes,
Yep.
is.
I know. Yeah, I know he's helping you,
Yes.
but you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right, and you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom, okay? So if you need to enter a piece of evidence into, I'm sorry, an exhibit into evidence, you're asking questions, you're gonna have to follow the same rules, okay? And just make sure you say yes.
Yes.
Thank you.
yes.
Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law, equity should prevail. I'm prepared to wrap this up and settle all of this. It be done here in this venue that's exclusive of Article 3. Constitutionally speaking.
Yeah. I appreciate that interest, but I can't. And let me explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here, I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's 2 charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the 2 parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these 2 gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here, we can't do that. The law does not allow me to resolve this case unless you were all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay.
Could you please repeat yourself the last 2 sentences, because I heard something in I want to make sure I heard it correctly.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me, there's no jury, and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least, Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's
okay. It's all right. That's what I'm here for.
And I do appreciate you bring up the Constitution, because the arrest regarding when I was arrested in this matter was done ex parte. I had no notice of this.
It's okay.
With their client.
An arrest warrant can be issued ex parte. The law allows that. There are rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've been reading that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says it just says an arrest without a warrant is illegal. But the Michigan law doesn't, Michigan law tells us what we can do or what, sorry, not we, but law enforcement can do, because they don't work for me, I don't work for them. They have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not
That's,
here to argue, I'm just
that's okay.
making you aware of what's happened.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th, sir. Thank you. We're on the record today, 28 on Circuit Court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhouten on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things the law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor, yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. No, it looks like the information was dated February 5th, but filed on the 6th. Now we're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first. Because a resolution means an agreement. Mr. Denhouten, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I'm sorry, I've checked off that block. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with an ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236 under section 600.576. Depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. I'm still trying to make sure all of this gets settled and closure in honor.
Oh, okay.
That would be another one of those envelopes that you.
Yeah. I understand. Okay,
If there's any other instructions or I
And you
fulfill
ref-
my duty that I'm aware of, but I'm willing to correct my mistakes.
okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay, and how do you think deposit? What did specifically again? Did you deposit?
A certificate of security.
Okay, and so what security was it that you tendered?
That was consideration
Or
for any outstanding liabilities, Your Honor.
okay, so your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right, so and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right, so are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, there isn't, you don't owe anything.
My knowledge, I do not. I have
No, so
my knowledge, I'm free and clear of liability, Your Honor.
No, liability is a different word. Liability doesn't apply here yet, right? There's no piece, there's no judgment that says you owe anybody money, so there's no liability.
Thank you for correcting me.
Yeah. Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
No, multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office a potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.
green card resent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium, so we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota, that's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're gonna get two bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhound reach an agreement, that's between you guys. I don't care what you guys deal with right outside. There's nothing to do with me. Mr. Denhound says they don't have an agreement, which means your offer has been, at least at this point in time, rejected. So now the next question here is, so that means we don't have a resolution today. I don't know, I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, because so far it doesn't end the case. You can't pay off a fine until I order a fine. So therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition. The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any
I'm not
body?
sure.
Yeah,
Sorry.
it's okay. It's okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, I believe it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here, and I'm just going to say on my discovery issue, still,
Your Honor, I stand corrected. I do have a copy.
never mind. I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those. You say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. Don't get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab. So things like that. So you can ask questions about discovery. But so far right now, it seems like you have it. But again, if you look at that police report, look at the last 2 pages, it will list all the exhibits, and you're going to want to make sure you've got those exhibits. And typically there's some kind of body camera. Now, by the way, unlike what they show on television, not every body camera works all the time. Not every body camera gets digitally downloaded for some reason. I don't know why, but you just can find out that information. And sometimes, by the way, they're muffled. Good luck figuring that out. All right. So we don't have a resolution. We don't have any discovery issues. The next question is do we have any motions? Now, Mr. Thompson, inside my schedule order, I said, if you have any motions, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay. Now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond. And there isn't a right to a trial. There is no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then if so, what should I do? Should I revoke bond? Should I remand the defendant into custody? Should I modify the bond? Or should I just wag my finger if they don't do that again? Now, do we want to have a hearing on that? Do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Misaki Community Corrections Program. Miss Stark, are you here for this one?
Yes.
I just want to ask you this question. Have there been any other alleged violations?
Two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right. Any I assume they've all been negative?
Just positive for THC.
All right, and that probably wasn't listed. Okay. All right. And by the way, Mr. Thompson, if you admit to failing to show up for those two tests, I'm just going to go with the finger wag. And say, don't do that again. Make sure you show up. Okay. Is it true you failed to appear for those two tests?
By mistake, I did, Your Honor.
Okay.
I apologize humbly to the court.
As long as you've been going to testing and you've been, and it just was on a couple different events. I will note they appear to both be on a Sunday. So I'm just going to say, make sure you don't. The court finds that there's been a bond violation, but the court is not going to revoke, modify the bond. I'm just going to do the finger wag. There we go. All right. Yes, sir. Anything else?
I wish to express gratitude, and I appreciate the court in its leniency. And I also want to let the court know that every day of my life is getting better.
I'm glad to hear that, Mr. Thompson.
I appreciate the opportunity to improve.
Well, guys, we've come to the end of both of these proceedings. And as we can see, Mr. David Thompson, not a whole lot different, when it comes to the sovereign citizen behavior, his beliefs, his ideologies. I've covered many sovereign citizens that, don't want to pay child support, trying to get out of child support. We also see that he's here in court for a controlled substance, but I've never seen any of them bring up something called the certificate of securities. And that's what I'm saying about a lot of these videos. We always see somebody come up with some type of different, argument with it, which is interesting and not interesting in a way that we think is going to work, but just when they explain it and break it down, like how he said that he believed he paid into this and that it would cancel out, later responsibilities such as child support and other things, which Judge Elmore shut it down and said, listen, that doesn't even apply here. Judge Elmore, definitely knowledgeable, knows what he's doing, has a great personality. He kept making reference to Dodger Stadium. So, as being his courtroom. So he's having, fun in there. But, there's a continuance, there's going to be a trial. We'll follow along with this case. And if we get the trial, if they air the trial, we'll definitely have it for you to see how everything else plays out for Mr. Thompson. But that argument obviously isn't going to work like the 1,000 other ones that we heard. But hey, if they're willing to keep trying, I guess we're willing to keep watching and keep commenting and talking about it. But with that being said, this is Sovereign Citizens Hall of Fame, guys. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. Talk to you soon. God bless.
Thompson.
That is the person that I was given to use in this life. And that proper style of upper lower case in accordance with SPR 89363, which is a court order to full faith and credit.
I'm going to speak one more time, and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple identifying questions because I've just called the case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes, I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure. Yep. Yes.
Are you David?
I feel really coerced right now. Thank you. I appreciate that.
Are you David Glenn Thompson?
I believe I just answered that with a yes, and I feel really coerced right now.
Mr. Thompson, I'm not going to allow ridiculousness to control the day in this court proceeding. I don't view this office as needing to allow that, and the law doesn't view this office as needing to allow it. I have a simple and straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this. You can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear, and it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause why you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the friend of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the friend of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up. I'd prefer to go back to them.
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, the law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based on my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter is, or should be aware of the fact that when posted, it couldn't be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears, if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you know, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court. But hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold equivalent. Registered mail to Clerk DeFider, I think it is. And why that wasn't credited to the account. Since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult, but it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article 3 court, or things referencing a surety contract or other words that, although they seem quasi-legal, don't bear any particular relation to this case. And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears-only matter. And I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes, and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard are present in this case, and that is, I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion to bar any further oral argument by Mr. Thompson. Instead, I'm going to follow the suggestion of the friend of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Blaine, on this case?
No, sir.
All right, thank you. The court is at recess on this matter then.
Well, guys, we have come to the end of this proceeding. And as we can see, Judge Hunter absolutely was not having any of the silly stuff that Mr. Thompson thought that he was going to bring to the table. He definitely tried to play games with the script that he had. He kept lifting up his paper. But as we can see, Judge Hunter was not having it at all. And it seems like the two words bench warrant were like a splash of cold water in Mr. Thompson's face, because as soon as he said those two words, it seemed like it snapped David right out of whatever game that he was trying to play. He seemed like it woke him right up, and he kind of, got himself together and realized, like, listen, this is not a game that you want to play. We see that he owed about $20,000 worth of child support, which now the bond that was posted, according to him, by a friend, and if it was posted by a friend, hopefully that friend read the fine print. But now that $5,000 to $6,000 that was posted, according to him, by his friend, it could have been by him, and maybe he felt by saying that it was a friend that posted it that they wouldn't touch it, but it was a part of the bond conditions. Now he owes about $14,000 in child support. But once again, this was my first time in Judge Colin Hunter's courtroom, and I definitely see he's not going to play any games with anybody because he was quick with it. He didn't even give it a second thought to play any type of games with it. And I know a lot of you guys out there, that's how you like it. So with that being said, guys, if we have a follow-up on this particular case, we will definitely share it with you guys. And that's pretty much it for now. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. God bless.
Ms. Warford. All right. Now calling the matter of the people versus Cinnamon Woodford. This is ticket number P1217275. Count 1, no plate on a trailer. Count 2, no insurance misdemeanor. Count 3, drive while license suspended. Appearance for the record, starting with, I don't think counsel is represented in this matter. So Ms. Woodford, state your name for the record, please.
I'm here by special appearance by coactus.
And what's your name?
Cinnamon.
Last name too?
Woodford.
All right, ma'am. Now, you know you have the right to have an attorney in this particular matter. This is a misdemeanor matter. And by right under law, you have the right to have a representative in the form of an attorney for this particular matter. Would you like to have an attorney in this matter?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be brought forth immediately so I can see who will indemnify me if I'm damaged.
Okay, so the question that I asked is that, did you want to have an attorney provided for you in this particular matter, Ms. Woodford?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be immediately brought forth so I can see who will indemnify me if I'm damaged.
Okay, Ms. Woodford, you're quoting from civil, well, not even civil procedure. Right now, you're quoting from the UCC. This is a criminal/traffic matter. So those proceedings govern these type of cases and these type of matters.
What crime did I commit?
Ms. Woodford, if you do not wish to participate, then what ends up happening is that this matter will go into a show cause. After the show cause, then it will enter into what's called a bench warrant for your arrest until you handle this matter, at least the misdemeanors. And these are all misdemeanor offenses. So that's how this is handled on this particular end and this particular point. The offenses that have been alleged at this point in time is that there were no plates on your trailer, that there was no insurance on a Chevy vehicle, that's a 2007 Chevy vehicle, and that the driver's license was suspended that you had. And so those are the offenses that have been alleged at this point in time. Right now, they are just allegations. So you have the right to have an attorney, which I don't know if you would like to have that right or not. You have the right to have a jury trial. You have the right to have a bench trial. A jury trial is a trial before 6 people of the community in the city of Detroit who come and they will hear the facts, and based on the evidence and based on the law will make a decision. A bench trial is the same thing, only a judge, being myself, would sit there and I would hear those same facts and evidence and apply the same law in the same way. You also have the right to plead to these matters. There can be an officer.
I'm not here to plead, ma'am.
Ms. Warford, these are your choices. So it's up to you. It's a decision that you have to make. It's not going to go away, okay? Just because you want it to go away, it's not going to go away. There is jurisdiction for it. So it's your decision on today. If you don't want to participate, then it's going to go into show cause, because you can keep coming and it's just going to hang out there. But eventually we're going to have to adjudicate this matter at some point in time, because it cannot remain on this docket indefinitely. So you have to make some decisions as to what you would like to do with these matters.
Well, I still do not consent to these proceedings.
So if you do not want to participate, I'm going to be forced to put it into what's called a warrant. You have to participate. So you have to come in and ready to go with something. I know you may not like it, but as a person who is a citizen of the United States of America, who is a person who lives in Michigan and is utilizing the services of our world and our community, these are the things that have been alleged. Now, if you're saying that the officer wasn't, correct in those or something, your license was valid or you had car insurance and you can present all of that, then we can try and figure out if we can get a new offer or something different. But other than that, you do have to stand for these particular allegations that have been made at this point in time.
Well, I never had a driver's license, so I still don't consent to any of these proceedings. So, I mean, I still don't consent to these proceedings. The offer is not accepted. So,
ma'am, you can stop reading that. I know they've given you a line cue that you are able to read off of, but this is as long as you utilize the services of everything in the city of Detroit and you fail to do those things, this is the ticket that proceeds. But I don't know that you failed. You said you don't have a license, but did you have car insurance at that time that you can present?
no.
Was it a trailer on the back of the vehicle?
Judge, I'm
Yeah.
sorry. I know I'm not on this case, but if I could file an amicus brief of sort. Judge, I'm a little uneasy with, this is Matthew Dupree, P80132. I'm a little uneasy with the questioning here, just because technically if this matter were set for trial, what she says here could be used against her. And so I'm not sure she should necessarily be answering those
You
questions.
want your representation, Mr. Dupree?
She did not, Judge.
Did you ask her if she wanted your representation?
I did, Your Honor.
Did the court ask her if she wanted her representation?
You did, Your Honor.
You can continue to talk, Mr. Dupree. I appreciate you stepping in on her behalf.
I appreciate that, Judge. Your Honor, I'm just I just thought I would make that representation. I don't think the city attorney would actually pull the transcripts, but it is worth noting that anything she said here, could come back. So it might, I'm not sure that necessarily that questioning would be appropriate. Sorry, Judge. Thank you.
You're welcome. Thank you, Mr. Dupree. I appreciate you coming in to step to the rescue of Miss Woodard so that she understands.
It's Woodford.
Woodford, sorry, ma'am, Miss Woodford. Miss Woodford? We have to make a decision. So how do you want to move forward with this?
Well, I'm not here to plead because I'm not here to
Would you like
plead.
a bench or a jury trial?
Are you making that determination for me, ma'am?
You have to have a bench or a jury trial. You told me you don't want to plead, that's fine. You probably should have a jury trial then. And I don't have any jury trials for this year.
Are you making that determination for me, ma'am?
If you don't make the determination, yes, the court is making the determination for you. Yes, because I have to move it. I have to move it. So it's either, well, Attorney Dupree, can I have a bench trial now? I don't want to violate anything.
No, Judge, she has to explicitly waive her right to a jury trial, and strictly speaking, she has to do it in writing. So I would say if she's saying she will not plead, that would be standing mute, and I think the court would have to set it for a jury trial.
Okay, that's fine. All right. So I'm gonna have to set this for a jury trial. I think she phoned. Oh, is she? Thank you.
And Judge, she logged off.
She was frozen, so it may just be her system. I'm gonna give her a second to sign back on. If she doesn't sign back on, I'll just put her in warrant status. But if she signs back on, I'm gonna try and give her at least a jury trial either.
Thank you, Judge.
Sorry about that. I had a very bad power surge.
I figured as much. So no, back on the record, I figured that it happened because you kind of froze up and my clerk informed me that you froze completely. So I.
Okay. Okay, thank you.
You're welcome. Okay. So I'm setting this for a jury trial because the alternate is that I can put this in warrant status. And I don't want to do that unless I necessarily have to. So at that point in time, you can be able to have your day in court. Just say whatever you want to say at that point in time.
Okay.
Okay. All right. So I'm going to, but I have to do a pre-trial because I don't have any dates right now. But I have your name down. But that will give you the opportunity. You will be able to talk to the jurors. You will have the opportunity to have testimony taken. I know you don't want counsel, but you can have the right to have counsel at that point in time. Would you like to have me assign counsel to you?
I need effective counsel at that.
Okay. I was going to say, would you like to have counsel assigned to you?
Yes.
Okay. So I'll get some counsel assigned to you. But I'm going to have you come back to make sure that that counsel is assigned to you. I am going to need some information from you, but not online. This is public to you. This is public to everybody, and I don't want them to have your business. Can you call the court this ends, ma'am?
Yes.
Okay. You ready to take down the number for me?
Yes, 1 second, please. I have to grab a pen.
Okay.
Okay, 1 second.
No problem.
Okay, I'm ready, ma'am.
313
965
965
22
93.
93.
We're just gonna need like your phone number and an email address, and then counsel will reach out to you and you'll be able to talk to them and then let me know. I'm gonna have you come back to court on 9/20/2022, just to make sure you have counsel in place. And then we'll try and see if I have any dates. I'm gonna ask them, can I have some dates for next year for jury trial, or this year if they have some. I would like to do them this year, but I'm gonna see what I can do, okay?
Okay.
8:30 a.m. I'm gonna set your bond at $0 personal. All that means is that you just come back on your own. No money is put down into place, okay? So I'm gonna call the courtroom so I can get that information, so I can send it over so that we can get you counsel assigned to you directly, okay? So that way you can handle this. You can have your day in court. You can say whatever you want to say within reason. You know, this is courthouse, so you haven't used any bad language or anything like that. And that's what I'm really referring to, okay? And you'll have your time and your day in court to dispute these matters, okay?
Okay, thank you.
You're very welcome. If there's nothing further, that concludes this hearing. You can go ahead and sign off, ma'am, okay?
Okay, have a good one.
You too, thank you. Don't forget to call.
Okay.
Okay, thank you. Now calling the matter of the People versus Cinnamon Woodford. This is ticket P1217275. Count 1, no plates on trailer. Count 2, no insurance misdemeanor. Count 3, drove while license suspended. Ticket number SP 1102227. Count 1, no receipt of registration. Count 2, no proof of insurance. Appearances for the record, starting with counsel, please.
Good morning, Your Honor. Harry Bachman for the defendant. Ma'am, state your full name.
Cinnamon Woodford.
Good morning, Ms. Woodford. Your Honor, the defendant is continuing and not guilty. We're asking for a waiver trial date by way of Zoom, please.
All right, if that's correct, ma'am, can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Ma'am, did you have an opportunity to talk to Attorney Bachman in private about your case and about your rights?
Yes, ma'am.
My understanding, you would like to have a bench trial. That's a trial before myself as the trier and finder of facts. Is that how you want to move forward, ma'am?
Yes, ma'am.
All right, I'm gonna set it for the date of December the 5th. December the 5th, that's gonna be at 9 a.m. It is going to be via Zoom. So the same way you zoomed in today, zoom in on December the 5th, 9 a.m., okay? Bond to be set at $0 personal. All right. There's nothing
Okay,
further,
thank
you're
you.
all set, okay?
Okay, thank you.
You're welcome, have a good day.
You too.
Cinnamon Warford?
Yes.
All right. Yes, okay, all right. Now calling the matter of the people versus Cinnamon Cheyenne Warford. This is ticket number P1217275. Count 1, no plates or trailer. Count 2, no insurance misdemeanor. Count 3, drove while license suspended. Also calling ticket number SP11022272. This is no proof of insurance. Count 1 of that same ticket is no receipt of registration. This is the date and time set for a bench trial in this matter. Appearances for the record, starting with Attorney Baughman, please.
Good morning, Harry Baughman for the defendant. Your name, please, ma'am.
Cinnamon Woodford.
Thank you, Ms. Woodford. These matters are set for trial. I do not believe there's been an officer who has checked in with the people being unprepared now at 11 a.m. approximately at the case was set for 9. We'd ask you to consider a motion to dismiss here without prejudice. Okay.
No officer having checked in on any of these matters, the court is going to grant your request. I'm going to dismiss these matters without prejudice. You're all set, Ms. Roper, okay?
Thank you.
You're welcome. Have a good rest of your day, okay?
You too.
Well, guys, we've come to the end of these proceedings, and truly there's not a whole lot of commentary here except on her first appearance. As we can see, she definitely was fed a script by somebody because, you know, she just was repeating that thing like a robot. Every little chance she got to cut in and repeat the script, she definitely did it. But I want to say shout out to the attorney. I know some of you guys don't like when the attorneys butt in, especially when the sovereign citizen or the individual say, you know, listen, I don't want an attorney. I don't need any attorney's help. But listen, this is what the public defender is there for. And a lot of times public defenders get bad raps, right? Sometimes people feel like they're in cahoots with the judge. You know, it's all a conspiracy. But shout out to the attorney. He stepped in. Definitely the judge was asking her questions that she probably shouldn't have been asking her. I definitely agree with that as soon as he started saying it. But nonetheless, he stepped in, helped her out a little bit. The judge gave her, you know, set her up for a pre-trial and then a trial, which we saw, but she set her up so she didn't have to give her a warrant. And as we can see with the second and third case, especially in that last proceeding, you know, the officer didn't show up, which we see that a lot. So because the prosecutor, you know, wasn't prepared when it came to their case, obviously the case was dismissed. And a lot of times we have that conversation about, you know, these officers not showing up. And you know, so many of you in the comments talk about how, you know, these officers need to be held accountable. Some of you feel like it's not that big of a deal, but whichever way you land or wherever you land at on that discussion, it is what it is. Officer didn't show up. Case was dismissed. Hopefully this young lady will learn her lesson. Maybe not, because I mean, she was riding around with no license, you know, a trailer hitched to the back of the car, no license plate on the trailer, all types of stuff. But with that being said, guys, as always, thank you for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, subscribe, and share. It is truly appreciated. And with that being said, guys, for now, Sovereign Citizens Court is adjourned. I'll catch you guys soon. Appreciate you, and God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.